In previous lecture, we started chapter 2 that was based on contract. And there were certain essentials of contract. Out of those essentials, there was essential of there must be agreement. Agreement means there must be offer and acceptance. What is offer? What is acceptance? We have covered in detail. The second essential was there must be consideration. And regarding consideration, we have covered so many things in previous lecture. So let's continue that consideration onward, and then we will move towards another essential. There should be a intention to create legal binding, mean there should be intention of both the parties. So chapter 2 is a big chapter. Probably today we will also cover chapter 2. Probably we will be able to complete this chapter 2 in next lecture. It's a big chapter of our syllabus. So let's discuss a concept of doctrine of promissory estoppel. Doctrine mean principle. Doctrine mean principle of promissory estoppel. Promissory estoppel mean if a person have made a promise, he can change his promise. Mean if a party in a contract has promised something to do, he can change his promise. Under what circumstances he can change his promise and what are the consequences? Let's discuss. So doctrine of promissory estoppel mean principle of changing the promise. So it is based on principle of fairness and justice. Mean you can change your original promise that you made while making the contract based on fairness and justice. It prevents a person going back on his promise. If you promise to do something while making the contract, so you can go back, you can change that promise to accept a lesser amount. Like if a person in a contract had a promise like you will pay me $100 on completion of the contract. Now that person can change the promise. Okay, you can pay me $50 and we can bind the contract. This is a promissory estoppel, changing the original promise to accept a lesser amount. The principle is subject to following conditions, but before moving to condition, let's discuss a case. There was a case between Central London Property Trust versus High Tree House. Central London Property Trust versus High Tree House. In this case, the High Tree House are the tenants and Central Property Trust was a landlord. So what was this case? Who is the claimant? Who is defendant? The Central London Property is the claimant and High Trees House is a defendant. So what happened? At the time of World War II, there was a contract between Central London Property and High Tree House, claimant and defendant. And there was a agreement, there was a contract of renting his buildings, renting his flats to the High Tree House. So claimant and defendant, they have a contract like claimant will provide a flat, will rent out his flat to the defendant at £2,500 per annum. This was the rent agreed between two parties. So claimant agreed like I will rent my flats to defendant at 2,500 per annum. And claimant knew that the defendant also sublet the flats to other people. He rented out property from Central London property and then sublet to other persons. But during the World War II, what happened? There was very few customer for the defendant. So he asked the claimant for the war period, can you please reduce the rent? Claimant said, okay, I will charge you half rent during war period. Mean I will charge you 1250 pound per annum during war period. So claimant let a block of flat to the defendant in 1937 at an annual rent of 2500 per annum. Mean this property renting their flats to this party at 2500 per annum. The defendant were then going to subject the flats owning the World War II and London being bombed. And during World War II, the London being bombed and the flats were in London. Some of the flats became empty and people leaving London mean this person suffering loss because he don't have customer to sublet flats other and it was impossible to re-let them. In addition, the existing tenant had their rent reduced, so the claimant agreed to accept half the rent for the rest of the war. So he said, okay, I will receive half rent for the war period. And afterward, what happened? Claimant asked for the complete price. So the full rent was payable from the end of the war. The doctrine of promissory estoppel would stop the claimant from recovering the full rent foregone during the war years. High Tree House was expected to reduce their rent as a result of a rent reduction by Central London Property Trust, which they did thereby providing their reliance on the waiver. In during war period, High Tree House have to pay 1250 per annum for the flat, but Central London Property refused to receive 1250. They said no, our original contract was 2500 per annum. But the court decided no, according to doctrine of promissory estoppel, mean you can change the original contract promise if you have a change, so contract will be according to that. When it was decided, no, the original promise was changed. So Central London Property is entitled to receive 1250 during war period, not after war period. But during war period, the rent must be 1250 because the original contract promise was changed by the claim. Can you understand this? So the doctrine of promissory estoppel means principle of changing the original promise. But this principle is subject to the following condition, mean these conditions must be fulfilled, then the original promise can be changed. There must be existing contract between the parties, mean there must be a contract between the parties of original promise that is going to be changed. And claimant must voluntarily waive off right, mean claimant have voluntarily, mean willingly waiving of the rights, mean asking, okay, I will receive 1250 rather than 2500. Must be intention that a defendant would rely on it and both parties must be willing according to this change in promise. And defendant must alter their legal position and defendant must alter their legal position mean he can take the right of legal position mean he can legally sue the claimant even if a claimant deny the change in promise. Mean these conditions must be fulfilled. And doctrine of a promissory estoppel has the following limitations. Suspensory effect. Suspensory effect mean the contract should be changed. Parties seeking it should have actually acted fairly mean both parties should act with each other fairly. And it is a shield, not a sword. It is a shield, not a sword. Mean the other party can claim can ask the other party to obey the change promise. It is a shield, mean it is a defense, not a sword. Sword mean it's not a something that you can impose too harshly. Mean this doctrine of promissory estoppel is work like a defense system. Like if this party denied 1250, they can ask the court in defense like the original promise has been changed. It is a shield, not a sword, means not that much strict. It is used as a defense. So can you understand this concept? The doctrine of promissory estoppel mean principle of changing the original promise. So next moving towards intention to create legal relation, mean the third element of contract, the third essential of contract. There was some essential of contract. There should be agreement between offer and acceptance. There must be consideration. Both we have covered. Now we are moving towards third essential of the contract, and that is intention to create a legal relation. Mean both parties should be willing to enter into the contract. So in order to create a contract, both parties must intend to enter into legal relationship, mean there should be intention of both parties, mean both parties should be willing. It is not imposed on them. If it is not clear from contract whether both parties are willing or not, then law presumes intention by type of agreement. Then there should be a written agreement between the parties. Mean contract could be oral as well. But if it is not clear from the contract whether both parties are willing or not, then there it's better the contract should be written form, mean there should be agreement. And in case of domestic or social agreements, it is presumed that there is no intention to be legally bound unless it can be rebutted. Rebutted means reverse. Like there could be a contract between two brothers, two sisters, between husband and wives. If there is any contract, and normally contract between brothers, sisters, husband, wives, they are not written, they are oral. So it will be normally assumed that there is the intention to create legal relation, mean both parties were willing. But in case of reverse case, it should be in a written form. Like if there was a contract between two brothers, like I will pay you something if you do this, and if other party haven't performed his promise, then one party can sue the other one. That is called rebutted, mean reverse case. Meaning the contract was not performed by the one party and other party sue for damages. So in that case, intention must be shown and intention must be proved in the court. So let's discuss a case. So Simkin versus Pace. In this case, Pace is a grandmother. Mean first party is Pace, second party is his granddaughter, and third party is Simpkins. So these three people, Pace, granddaughter, and Simpkins, they agree to put our money into the lottery. Mean, suppose the lottery amount was $90, so $30 shared by Pace, $30 paid by granddaughter, and $30 paid by Simpkins. Mean they all together put the amount into lottery of $90 and shared equally between these three people, Pace, granddaughter, and Simpkins. And in a lottery, Pace mean grandmother did something positive. Mean she guessed the lottery. She made a guess to win the lottery. As they won the lottery, and the lottery amount they won £750, and they both refuse to give a share to Simpkins because as I guessed the lottery amount, I made the guess and we won the lottery because of my guess. So they refuse to pay the share to the Simpkins. But court decided no, as you all were equally contributed to the lottery amount of 90. So out of this 750, you need to pay the share of Simkin as well. Because you all three were in the contract. While buying the lottery, you all three contributed the amount. So while you received the amount, if you won the lottery, you have received 750. This means in the 750, there are three shares of you, your granddaughter, as well as Simpkins who contributed in investing in the lottery. So Pays and her granddaughter, Pei is a grandmother and her granddaughter, second party, together with Simkin, third party, are paying a lodger, submitted an entry each week in a fashion competition appearing in the Sunday Empire News, lottery. All three devised a separate solution to the competition, but they were submitted on one coupon only. There was one coupon of 90 and all contributed 30 each. In Pay's name, but they invested the amount in Pay's name. The entry fees and postage were shared equally. All three, 19, 30, 30, 30. The granddaughter made a correct forecast and Pays received a price of 750 and they refused to share this 750 with the Simkin. So Simkin sue a case against Pays. So Simpkins claimed a one-third share of the prize money. And the court decided, oh, though you all three were in a contract, so the amount that you have won must be shared between you all three. Can you understand this concept? So in case of domestic or social agreement, it is presumed that there is no intention to be legally bound unless it can be rebutted. Rebutted mean reverse, mean if one party refuse to complete his promise, in that case, you need to clear the intention. But in case of commercial agreements, business agreements, it is assumed that there is an intention to be legally bound unless proven otherwise. In commercial agreement, it is will always be assumed that there is a legal intention. So let's move towards another concept called privity of contract. Privity of contract. Privity mean rights. If there is a contract between two parties, A and B, this means if there is a contract between A and B, if A do not meet his promise, B can sue A for damages. And if B do not complete his promise, A can sue B for damages. Mean if there is a contract between two parties, they are having to sue each other, mean they are having a right to sue each other. So only parties to contract, mean A and B, acquire rights and obligation under can sue and be sued on it. Mean they can sue each other only. Third party like C cannot sue A or B in case of there is a breach of contract between A and B. So C cannot sue A either B because there is contract between A and B. And C cannot sue in case of breach of contract either to A or to B because he is not a part of the contract. If there is a contract between A, B, and C, then C can sue A or B in case of breach of contract. So privity of contract means rights of contract Who has the rights of contract to sue other? Only parties in the contract. But there are some exceptions. If A and B are having a contract with each other, and according to that contract, C will receive the benefits. I mean, if A and B are having a contract, like A or B has to do something, and according to that act, C will get the benefit. C is a third party. There is a contract between A and B, and C will get the benefit of that performance of the contract. And either A or B didn't perform the contract. As they didn't perform the contract, but who didn't get the benefit? C. In that case, C can sue A or B for the damages. If C is not involved in getting benefit, then he will not sue the other parties. So only parties to contract acquire rights and obligation under can sue and be sued on it, but there are exceptions. Right of Third Party Act 99 allows a person who is not a party to contract, mean C, to enforce if contract was for his benefit and he was expressly identified by name or description, and A and B, while making the contract, knew that our contract will provide benefit to C. And if in case of breach of contract by A and B, obviously C couldn't receive that benefit. So in that case, C third party can sue A or B for the damages. The first one. Mean when third party can sue the parties of the contract, when the contract is for the benefit of third party and both parties expressly knew about it. Let's discuss a case. Beswick versus Beswick, 1967. There is a case, a coal merchant sold his business to his nephew in return for a pension during his lifetime. Mean a person B sold his business to his nephew and asked the nephew, you will run the business and during my lifetime, you will pay a pension amount to me. And when I died, you will pay the pension amount to my wife, widow. So what happened? This nephew was paying pension to B during his lifetime, but when he died, he refused to pay pension to his wife, mean widow. The court case decided no. As the contract was between you and B, and there was a term that after my death, you will provide this pension amount to my wife. So you have to pay this amount to wife. So wife can sue nephew for damages. So a coal merchant sold his business to his nephew in return for a pension during his lifetime and the payment of a smaller pension to his widow. Obviously, widow will become after his death. On his death, after the uncle died, the nephew stopped paying the widow. She sued the nephew in her own personal capacity and in her capacity as the administrator of her husband's estate. Although she was not a part to the contract, I mean, there was a contract between uncle and nephew. But as this contract is going to provide benefit to this third party, his wife, so she can sue any of the party for the breach of the contract. So although she was not a part of the contract and could not sue in her own personal capacity, she could sue in her capacity as she administrator of the husband estate. Can you understand this one? Privity of contract means who has the right under the contract to sue other in case of breach of contract? Only parties to the contract. But third party can sue either of the party to the contract if the contract was to provide benefit to third party. There is another exception. If there is a collateral contract between one of the parties and third party regarding subject matter, collateral means extra contract. In case of collateral contract, mean with the main contract, there is another contract. Collateral mean another extra contract. In that case, the third party can sue for damages to parties of the contract. What does that mean? Let's discuss another case. Shanklin Empire versus Dattel Products. Dattel Products. Dattel Products was the paint manufacturer. Dattel Products was the paint manufacturers. And Shanklin was a house owner or building owner. They had a contract with the contractor. Like the contractor was building the house of Shanklin. If contractors are building house of Shanklin, ultimately after building the house, they need to paint it. So Shanklin asked Dattel Products regarding the quality of their paint. And Dattel product provide information to Shanklin like our paint will last up to 7 to 10 years. And based on that information, Shanklin asked their contractor, you need to paint my house with the Dattel products paint. And there was a contract between Shanklin and contractor. Shanklin building his house through contractors and asked the contractors to use paint in my building of Dattel products because according to their information, their paint lasts 7 to 10 years. So as per request, contractor use the paint of Dattel products, but that paint flake after 3 months. And Shanklin sue the Dattel products like as per your information, your paint didn't last for 7 to 10 years. And Dattel products said there is no contract between you and us because who bought paint from us, contractor, not you. So you cannot sue us. But court decided no. As the paint bought by contractor from Dattel products, there is a contract between Dattel products and contractor. But as that contract is providing benefit to Shanklin, and there is a separate contract between Shanklin and Dattel products because they asked you for information, the quality of your paint, and you said our paint lasts 7 to 10 years. And based on that information, they asked their contractor, they requested their contractors to use your paint. So they can sue you. You have to provide the benefit, you have to provide the damages of Shanklin. So the claimant owned a fire mean building, and wanted it repainting. They contacted Dattel, a paint manufacturer, to inquire about the quality of the paint and were told it lasted 7 to 10 years. The claimant employed contractors to do the painting and specified that dental paint be used. And based on that information, Shanklin asked their contractor use the paint of dental products. The contractors completed the painting, but the paint began to flake after only 3 months. The claimant, means Shanklin, sued dental products, who argued that there was no contract between us because who bought the product from us? Your contractor, not you. But there was a collateral contract between debtor and claimant because while asking information about the paint, there is an other contract of main contract between contractor and debtor. So debtor has promised that the paint would last 7 to 10 years, and claimant request for the contractors to use debtor paints was consideration for that promise. So in court case, it was decided, no, you have to pay damages of the Shanklin, though your main contract was between contractor and you. But there is a collateral, means separate contract between you and Shanklin as well, while asking the information, because based on that information, they requested their contractor to use your paint. Can you understand this concept? Mean only parties on the contract has a right to sue each other, but there are some exceptions. If the contract is to provide benefit to third party, then third party can sue parties of the contract. And if there is a collateral contract with the third party, then the third party can sue parties of the contract. And the third exception, in case of agency law, contract is made by agent, whereas liability is of principal. What is agency law? What is agency concept? According to agency concept, there are two parties. One is called principal and other is called agent. Principal engage agent to perform some services on behalf of the principal. In agency, one party called principal who engaged agent to perform some services on behalf of a principal. Like if Mr. A is having a business and they appointed their agent Mr. Y to manage their business. This means Mr. Y, whatever he is doing on behalf of Mr. A. And if Mr. Y has a contract, suppose with Mr. Z, and Mr. Y breached the contract, so Mr. Z can sue either Y or Mr. A as well, because Mr. Y is working on behalf of his principal, Mr. A. Though there is a contract between Mr. Y and Z, mean Mr. Z can sue Mr. Y. No, as Mr. Y is agent of Mr. A, so he can sue Mr. A as well. So what does that mean? In case of agency law, contract is made by agent with other party, whereas liability is of principal, mean other party can sue principal as well, because the agent is working on behalf of principal. And the other party knew about this, like he is an agent and he is working on behalf of that principal. So only parties to the contract can sue each other in case of breach of contract. Third parties cannot sue the party of the contract. But there are three exceptions. If the contract between two parties is for the benefit of any third party, then in case of breach, third party can sue either parties of the contract. And if there is a collateral contract between one of the party of the main contract, then that party can sue the parties of the contract. And in case of agency law, if a breach of contract made by the agent, the third party can sue the principal because he knew that agent is working on behalf of the principal. Privity of contract. Mean rights of the contract. Who has rights of contract to sue other? only parties to the contract, but there are three exceptions. In case of land law, restrictive covenants runs with land to which they relate, i.e. further honor will be subject to restriction. Suppose Mr. A bought a land from Mr. B. And this was the land Mr. A bought from Mr. B. And while buying the land, there is a term, covenants. Covenants mean condition. What was the condition? Mr. B imposed a condition to Mr. A. You are buying this land from me, but you can build on this land, but not on this part. You can build here only. You have to keep this space empty. You cannot build on this part of the land. This was the condition attached to the land. And if Mr. A sold the land to Mr. C, Mr. C sold the land to Mr. Z, Mr. Z sold the land to Mr. Y. This means this condition will be imposed on C, on Z, on Y as well. Mean these party even cannot build anything on this part of the land. Mean in case of land law, though there was a main contract between A and B, there was a restriction, there was a condition between A and B, you cannot build over this part of the land. But in case of land law, this condition of the main contract will be imposed on the other parties as well. So in the land law, restrictive condition runs with the land to which they relate, i.e. future owners will be subject to that restriction, mean that condition as well. In future, Z and Y cannot say, no, there is no contract between us, like we cannot build on this part. No. According to main contract, if there is any restriction in a land contract, so that will be imposed on future owners as well. Can you understand this? Mean if they build anything in this part, he can sue them because that restrictive covenants will transfer to them as well. Let's discuss a case. Talk versus Moxie. He is a defendant. No, he's a claimant. He's a defendant. The owner of several pieces of land sold a plot to another party, making a covenants condition to keep a particular area uncovered with building, mean on this area you cannot build anything, such that it could remain a player ground, mean it should be open ground for children playing area. Over the following years, the land was sold several times over to new parties, eventually to the defendant. Mean Moxie like Mr. Y or Z in our example. The defendant who was aware of the covenants, he knew that there was a condition do not build on this part of the land. At the time of purchase, refused to abide by the covenants, as he claimed he was not in privity of contract, mean at that time when this condition was imposed, I was not there. This was not with my contract, and so was not bound by it. So I can build because there is no restrictive condition between you and me. So court case decided an injunction was granted against defendant to restrain a breach of the covenant. Why? Because the original covenant restrictions will be transferred to the future owners as well. No, he is bound according to the original contract. Can you understand this? An executor can enforce contract made by deceased for whom he is acting. An executor can enforce contract made by deceased who is acting, like if there is a contract between A and B appointed a executor C, like you can make a transaction on my behalf. Though there was some terms between A and B, these are the parties to the contract. But on death of B, in case of breach of contract, C even can sue A because C is a executor of B. Because B has nominated C as his executor, he will execute all the transaction on behalf of B. Only parties to the contract can sue each other, but there are some exceptions. Those exceptions are 5. If the contract is to provide benefit to third party, then third party can sue parties of the contract in case of breach. If there is a collateral contract, so according to collateral contract, a third party can sue either of the party. In case of agency law, any breach of agent, the third party can sue principal as well. And in case of land law, if there is any restrictive conditions attached to the contract, so that those conditions will be imposed upon the future owners as well. And if an executor is executing a contract on behalf of the deceased person, then he can sue the party of the contract being a executor. And there are some other exceptions. Insurance law allow a third party to take the benefit of a contract of insurance. For example, where the policy is for life insurance, which will pay out to third party in the event of policyholder's death. Like in case of life insurance, if a person died, their representative like children or wife can ask for recovery of amount from the insurance company. Though there was a contract between the person and insurance company, but if that person is died and there was life insurance, ultimately insurance company have to pay insurance premium to whom? The representative, mean his children or wife. Trust law allow a beneficiary to enforce a trust if in a trust law, like one party is working as a trustee of other party, and if other party dies, the representative can make claims from trustees. And agency we have already covered, and executive we have already covered. Privity of contract. In only parties to the contract are having right on each other to sue each other. But there are 5 exceptions. If the contract was to provide benefit to third party, then third party can sue the parties of the contract. If there is any collateral contract along with the main contract, then third party through collateral can sue any of the party for breach. And if any agent is working on behalf of principal, the third party can sue the principal in case of breach by the agent. In case of land law, if there are any restrictive covenants attached to the sale of land, then the future owner will be bound to follow the conditions of original contract. And if any executor is appointed to made transaction to execute a transaction on behalf of a person, and on the death of that person, executor can sue the parties of the contract. Let's moving forward. Statement of contract. Statement of contract means what is written in the contract, that is called statement of contract. So statement made during the negotiations leading to a contract. Mean what are the main points of the contract, that is called a statement. And statement of two types, either it could be term or it could be representation. Term is a major clause of the contract that are usually mentioned in the contract. Like this party has to do this, other party has to do this. These are the major clauses that are usually mentioned in the contract is called term. What is representation? Sometimes that is said by offerer to induce offeree into the contract. I mean, these are not the major clauses. These are the things that offerer explained to the offeree before the contract. So if there is a contract between A and B, A will provide a product to B and B will pay the money to A. But before making this contract, A provided some information about his product, like if you bought this product, we will provide you this benefit in future. But these are not written in the main contract. And those extra things that offer to the offeree before the contract, these are called representation. In case of breach of contract, in case of breach of terms, it will be considered serious. And in that case of a seriousness, damages must be provided to the injured party. To the innocent party, sorry. Injured party will provide damages to the innocent party. But representations, sometimes that is said by offerer to induce offeree into the contract. And if a breach, this will be considered a minor breach and compensation is provided, not the damages, compensation is provided. While breach of terms will be considered serious, not minor, serious. And in that case, damages must be provided by the party to the innocent party. So statement mean what is included in the contract. Those could be terms, mean major clause, or representations, mean minor clause. And in case of minor clause breach, compensation will be provided. In case of major clause, mean breach of terms, damages will be provided because this breach will be considered serious. If representation become a term of contract, innocent party has a remedy, means solution for breach of term as well as representations, mean damages as well as he can claim for compensation as well. So statement of contract offer of two types, terms, major clause, representation, minor clause. Breach of terms will be considered serious breach. In that case, damages must be provided to the innocent party. While representation is a minor clause, and in case of a breach of representation, no damages, only compensation will be provided. Source of terms mean how terms can be included. Terms can be included in the contract either expressly or impliedly. Expressly mean by mentioning either written or orally. So express mean mention in contract by one of the party, and they must be clear to be enforceable. Mean both parties have clearly expressed the terms. Implied terms that are not expressed. Like if you are employing any people in your business, it is implied you cannot dismiss unfairly that employee. It is implied like you have to provide a good working condition to the employee. These are not expressed, but these are implied, either implied by statute, mean employment law, either by custom. Obviously, it's a custom. Like if you are employing any people, you will not dismiss unfairly. Or by the court, our court will impose that terms. So terms could be expressed, mean mentioned in the contract by one of the party, are implied, not mentioned in contract, but still part of the contract, and they are implied by the statute, mean law, by custom, or by the court. Express terms generally override implied terms. Express terms generally override implied terms. Like you can express anything to override implied terms. However, some statutory terms cannot be overridden by the express agreement. Mean you cannot say, okay, while working, you might be dead or might be injured. No, this is covered by statute. You should provide good working condition. There shouldn't be any chance of death or injury at the workplace. But you can say, okay, after 6 months, I can dismiss you. So this is express term that is overriding implied terms. But statutory terms means statutory implied terms cannot be overridden by express agreement. So statement of the contract could be either term or representation, and the terms could be either express or implied. There are three types of terms: condition, warranty, innominated terms. Condition, warranty, innominated terms, and it is very important to make distinction between these three words: condition, warranty, and innominated terms. What is condition? The most important term of the contract, mean root cause of the contract. If breach, remedy can be damages, discharge, or both. The most important term of the contract. The main cause, the root of the contract. If any party breach the condition, the other party have to pay the damages, or the innocent party can discharge of the contract, or he can ask for damages as well as discharge. While warranty are the less important terms, that is incidental to the main purpose of the contract, mean these are not most important. And in case of breach of warranty, the remedy means solution is a damages only, not the discharge. And you will receive only damages. You cannot say, okay, I want to discharge the contract. Let's discuss with the court case. So condition is an important term going to the root of the contract. Breach can result in damages or discharge or both. Discharge entitles the innocent party to repudiate the contract and claim damages, mean they can cancel the contract and they can ask for damages. There is a case between Passard versus Spires and Pound. So a soprano, Madame Passard, agreed to sing a series, mean P agreed to sing in a concert. Who was arranging the concert? S and P, they were arranging a concert. And that concert was, say, for 6 days, means 6 nights. P need to sing for the concert of S and P. But on the opening night, P failed to present, P failed to sing. And on the second day, when P arrived at the concert, they refused because on the opening night you were not there. And P ultimately sued the S and P for the damages. So, as Madame Passard agreed to sing in a series of operas for Spicer's, she failed to appear on the opening night, and Spicer refused her services for subsequent nights. The court decided the obligation to appear in the opening night was a condition because obviously you have to be present there on the first night, because according to your first night impact, people will come to the concert to listen to your song and they will be coming onward. If on the opening night you are not there, that is the main day of the concert, and you are not there, and for other day if you are there, they can cancel the contract. This means she was not liable to receive any damages because it was a main clause of the contract, like you have to sing for 6 days, and ultimately this will start from the first day. This means you breach the most important term of the contract, and that was first night, opening night, because the opening night will create a for the other nights, other days. So Spicer was entitled to treat the contract as at an end and was therefore not himself in breach by refusing her services for the remaining nights. Mean, if she sued the Spicers for the damages, she is not entitled to receive any damages because she breached the contract by herself, because she breached the condition, mean most important term of the contract. So terms of three types: condition, the main root of the contract, the most important term of the contract; warranty, less important term of the contract. Let's discuss another case of warranty. A warranty is a less important term, which is incidental to the main purpose of the contract. Breach of warranty result into damages only, not repudiation. There is a case between Bettini and Guy. Bettini is a singer, and there was a contract between Bettini and Guy. Like Bettini has to sing for concert of Guys. But before the concert, Bettini had to attend 6 days of rehearsal. And she was not there for the first 2 days of the rehearsal. She was present for the other 4 days of the rehearsal as well as for the concert, but she didn't attend the first 2 days of the rehearsal. And Guy, they refused the contract. And Bettini sued the Guy for damages, and court decided that rehearsal is not the main root cause of the contract. That is not a major clause of the contract. That is less important term. The main contract is to sing on the concert rather than attending the rehearsal. So that's why Gay was liable to pay damages of the Bettini in case of breach of contract. So a tenor Bettini who agreed to sing a series of concert and to attend 6 days of rehearsal, therefore had failed to appear for the first four rehearsal days. Guy is in consequence refused Bettini services for the balance for the rehearsal and performance. The court decided the obligation to appear for rehearsal was warranty, not a condition. This was not most important term, this was less important terms. And therefore, Bettini breach didn't entitle Guy to treat the contract at an end, mean they cannot terminate the contract, they cannot discharge the contract, they can ask for damages only. So Guy was accordingly in breach of contract when he refused Bettini services for the remainder of the contract. Because attending rehearsal days was a warranty rather than condition. If she is not there for the concert, that will be a breach of a condition, most important term. That was in previous case, P versus S&P. So there are three types of terms. Condition, the most important term of the contract, that is main root cause of the contract. And if condition is breached, the innocent party can ask for damages as well as discharge or both. But warranty is less important term, that is incidental to the main purpose of the contract, mean not main root cause of the contract. In case of breach of warranty, the innocent party can ask for damages only, not discharge. What is the innominate terms? Term which is neither a condition nor a warranty. In that term, that is not a condition, not a warranty. Remedy depend upon breach, mean if innominated terms are breach, what could be the remedy, what could be the solution? If trivial, trivial means unimportant. This will be treated as warranty. But if serious, innominate terms are serious, then treated as condition. So there are three types of terms. Condition, the most important term of the contract, the root cause of the contract, and breach of condition will result into damages or discharge of contract, or both damages and discharge. Warranty is a less important term of the contract. That is not the main root cause of the contract. In case of breach of warranty, the remedy will be damages only, not discharge. But innominate terms is neither condition, neither warranty. And in case of breach, if it is trivial, it will be considered as a warranty. If it is serious, it will be considered as condition. Let's take a break, small break. After break, we will discuss the next topic, exclusion clause.
Okay, sir.
So are you there? What we have discussed so far? What we have discussed so far today? We have discussed doctrine of promissory estoppel, intention to create legal relation, treaty of contract, statement of contract, are of terms are representations, and sources of terms are express are employed, and there are three types of terms: condition, warranty, and innominate terms. So let's move forward. Exclusion clause. Exclusion clause, also known as exemption clause, is a term that seek to exclude or limit parties' liability for breach of contract. I mean, parties to the contract can include a term like in case of breach of contract, party can exclude themselves or limit themselves for liability. The exclusion clause are known as exemption clause. Means sometime in a contract, parties can include, like in case of breach, what will be the liability that each party will pay to each other, or there will be no liability. So is the exemption clause in terms of seeks to exclude, either they can exclude from liability or they can limit liability in case of breach of contract. And there are rules that need to be followed while setting out exclusion clause. Common law rules and statutory rules. And what are the rules to include exclusion clause into the contract? Mean where parties can limit their liability or exclude themselves from liability in case of breach of contract. An exclusion clause can be included in the contract according to common law rules, according to statutory rules. Mean what are the rules to include exclusion clause into the contract? According to common law rules, in order to be valid exclusion clause, mean exclusion clause will be valid if it must satisfy two conditions. First condition must be incorporated into the contract, mean must be included into the contract. This is called incorporation control. And wording must cover the loss, mean what could be the loss? The wording must cover it, and it will be called interpretation control. Mean exclusion clause will be valid according to common law rules if it satisfy two conditions: incorporation control and interpretation control. Incorporation means that must be incorporated into the contract, and this we need to cover in more detail. Incorporation into the contract. An exclusion clause can be incorporated into the contract by signature of both the parties. I mean, clause is incorporated by signature even if signatory did not read or understand the document. Like if we are making any contract with other party, like we are going to buy our train ticket, and on back of the ticket there are certain terms written on it. Like, train can be cancelled anytime. There could be delay in a train timing. Either you have read those terms at back of the ticket or not. And if you have signed on the ticket, this means you are creating intention to those terms as well. If there is any exclusion clause from the train company that is written on back of the ticket, either you have read or not, it is your mistake, but companies can include this kind of exclusion clause in the contract. An exclusion clause can be incorporated into the contract by signature of both the parties. Even both signatories didn't read or understand. Obviously, one party intentionally have mentioned something, and if other party didn't read that one, so there is no excuse. Like I haven't read that. No, if you have made the signature, you have accepted the contract. So you have to go through all the conditions. Let's discuss a case. Thompson versus RMS Railway. So Thompson T is a claimant, RMS is a defendant. So T bought a railway ticket which stated that she would travel subject to the company's standard condition of carriage. These conditions could be inspected at the station. One of them excluded liability for injury to passengers. In case of any injury to passenger, RMS Railway stated on back of the ticket, we will not be liable. And T was traveling on the railway, was unable to read and so was unaware of this clause, and she was injured and claimed damages. So according to court case, she is not entitled to claim damages because the injury damages were excluded from the contract and it was incorporated into the contract by stating on back of the ticket. So the ticket was a document which should be expected to contain terms being more than a mere receipt for payment. And if you are buying a ticket, mean there is a contract between you and the ticket provider. The railway company had taken reasonable steps to bring the exclusion clause to the passenger. Mean it is expressly stated at back of the ticket. If you haven't read that, that is your mistake. There is no excuse. Unintention by incorporating into the contract document the ticket. So T was bound by the clause even though she could not read. Illiteracy is a misfortune, not a privilege, as were all other passengers. So T cannot ask for damages in case of injury. So parties to the contract can include exclusion clause. Exclusion clause mean to limit their liability in case of breach or exclude liability in case of breach. But exclusion clause can be included using common law rules or statutory rules. First, we are discussing about common law rules. According to common law rules, that exclusion clause must be incorporated into the contract. How it can be incorporated? By signature of both the parties. Or exclusion clause can be incorporated by a notice. I mean, reasonable steps should be taken to bring exclusion clause to attention of other party. A clause can be incorporated by notice if it was given before making a contract. What was that mean? Notice. Let's discuss another case. Ole versus Marlborough Code. A clause can be incorporated by notice, provided it was given before making the contract. A notice in a hotel room didn't exclude liability as the contract was made at the reception desk. In a hotel room, on the door of the room, there was a page saying hotel will not be liable for any lost items. Where it was stated on the door of the room. While any customer who is coming to the hotel, he's making a contract, mean making a payment and booking a room where at the reception desk. At reception desk, this was not providing to notice of the customer like a hotel will not be liable for any lost items. So while making the contract, this notice was not given to the customer because the contract is made on reception desk. And after reception desk, after the contract, he is moving to the room. And on the room door, it was stated hotel is not liable for any lost items. And if the customer lost his item, he can sue the hotel for damages. Why? Because while making the contract, it was not given into notice of the customer. So you need to put into notice of the customer. You need to put into notice of the customer while making the contract. In on the reception desk, you have to put this note. On the main door, you have to put this note like a hotel will not be liable for your lost items. Then this notice has been given to the other party. This means hotel can exclude from liability in case of lost items. But after making the contract, if you are giving into notice, so that will not be considered as exclusion clause because it is not incorporated into the contract while making the contract. The notice was not given. So exclusion clause can be incorporated into the contract by signatures or through notice. I mean, reasonable steps should be taken to bring exclusion clause to attention of other party about the exclusion clause. The clause can be incorporated by notice if it was given before making a contract. If that note page is on any of the wall of the hotel, that cannot be seen by the customer while paying for the room, while booking for the room. So it is not given into the notice. If it is inside the room, if it is on the door of the room, so that notice was not given to the customer while making the contract. This notice should be put on the reception desk, on the main door. Either customer have seen that or not, then you can say the notice was given to the party about the exclusion clause. So exclusion clause can be incorporated by signature, by notice, or by previous dealings. What is meant by previous dealings? If A sold some products to B and to B, they send a receipt, and on that receipt, there is exclusion clause written. Like in case of damaged item, we will not be responsible. So this exclusion clause given into the notice of the B for selling the goods. But if B is buying goods from A on regular basis, this means on next buying, he is aware about the exclusion clause. And if on fourth or fifth buying, he received some damaged products and then he claimed for the damaged products, he cannot claim because he is new about this exclusion clause through previous receipt, like A is not liable for damaged goods. This is called previous dealing incorporation. For an exclusion clause to be incorporated by previous dealing, mean previous receipts saying we will not be liable for damaged goods. So in future buying, you cannot claim for damaged goods if you have received. While receiving, you have to make sure whether goods are okay or damaged. So there must be consistent course of dealing between parties, and there is a case as well. Previous dealing. For an exclusion clause to be incorporated by previous dealing, there must have been a consistent course of dealing between the parties. Sperling versus Bradshaw. Sperling is a claimant, Bradshaw is a defendant. So the defendant, Bradshaw, had dealt with the claimant for a number of years. I mean, there was transaction between these two parties for a number of years. On the contract in question, he delivered 4 full barrel for storage. 4 full barrel for storage. Mean he delivered full 4 barrel for storage. As usual, he later received a document which acknowledged receipt and contained a clause excluding liability for negligence. Negligence means if any barrel is empty or damaged, who will not be liable. On receipt, mean after delivering the good, he is delivering receipt, and on that receipt it was written. When he came to collect the barrel, he found they were empty. Not the first order, subsequent order. And he asked for the damages. So the exclusion clause had been incorporated into the contract, even though it was received after the contract was made, but previous receipt, he should knew about this clause because it is written on all the receipts, even in previous, even in the new. It had been incorporated though through the previous course of dealing whereby he had been sent copies of document containing the clause, even though he had never read that. So he was not entitled to receive damages for the empty barrel or damaged barrel because it is based on previous dealings. However, however, Sperling versus Bradshaw can be contrasted with the Hollier and Rammer motor, in which there are 3 or 4 days between a garage and a private consumer over a 5 years period were held to be insufficient to constitute a course of dealing. Later on, there was a case between H and RM, and there were not frequent deliveries between H and RM. In a 5 years, there were only 3 to 4 deliveries. As per previous dealings was too late, or there was a much gap between the deliveries. So in that case, this exclusion was not considered to be incorporated because on frequent deliveries, you are aware about the exclusion clause. But in case of infrequent deliveries, like in 5 years period, there were 3 or 4 deliveries. So this exclusion clause of incorporation using a previous dealing was not considered as a exclusion clause. I mean, there should be regular dealing. The previous dealing should be on regular interval. If the interval between the delivery is too much, in that case, this exclusion clause will not be considered valid. So exclusion clause can be included, incorporated into the contract by signatures, by giving a notice at the time of making the contract, not after making the contract, or by previous dealings. And wording must cover the loss. I mean, there are 2 conditions that must be fulfilled. First, it must be incorporated, and second, wording must cover the loss. Mean what could be the loss that can be covered by using the exclusion clause? Mean what will be the limit of the damages? So under contra preferentum rules, court interpret word narrowly against interest of person seeking to rely on clause. Mean the wording must cover the loss. Mean what could be the limit of the loss? So exclusion clause can be incorporated according to common law rules that we have covered. According to common law rules, it must fulfill 2 conditions, must be incorporated by signature, by notice or previous dealing, or wording must cover the loss. And the second rule of exclusion clause is a statutory rule. What is statutory rule? Let's discuss. Even if clause passes common law test, it must satisfy statutory rules. And according to statutory rules, there are 2 acts that we need to deal with: Unfair Contract Terms Act and Consumer Right Act. Unfair Contract Terms Act, this is from business to business transactions. Meaning a business is dealing with another business, then how the clause can be included into the contract. So this applies to exclusion clause in business to business contract. It states that clause excluding liability for death or personal injury due to negligence is void, mean you cannot make exclusion clause of relating to death or personal injury of any of the party. This will be considered void clause, not valid. And other loss due to negligence is void unless reasonable. And any other loss due to negligence of one of the party in business to business case will not be considered as a valid exclusion clause. This will also be considered as void. So in case of business to business transactions, you cannot include exclusion clause of death or personal injury due to negligence. And you cannot include exclusion clause due to negligence, due to loss due to negligence, that will also be considered void. Let's discuss a case. I'm sorry, there is no case for that. So just to remember, according to statutory rules, Unfair Contract Terms Act says while dealing between business to business, the exclusion clause relating to death or personal injury due to negligence is not considered valid. And a loss due to negligence of any of the party will not be considered valid. It will be considered void. And while assessing reasonableness, court consider strength of bargaining position of party, mean both party should be on equal position. There shouldn't be one party on heavy position and one party on lower position while including exclusion clause. Whether there was inducement given, mean perception, mean willingness given by both the parties, ability of party to provide compensation, whether both parties know about the compensation, and whether party knew about intent of term, extent of term, mean up to what extent the terms can be included into the contract. I mean, just cramming, there is a nothing concept in this topic. And if you are dealing between business to consumer, in that case, CRA, Consumer Right Act 2015 will apply according to statutory rule of exclusion clause. And according to Consumer Right Act applies to exclusion clause in business to consumer contract. And this act state that clause must be expressed in simple and plain language. Mean if you are including exclusion clause while dealing between business to consumer, so it must be expressed into the contract in simple and plain language, mean easy to understand, and it should create imbalance amongst a party. It should not create imbalance amongst parties, mean both parties must be on balanced position, mean both parties must be on win-win situation rather than win-lose situation. So exclusion clause can be included into the contract according to statutory rule and according to common law rule. According to common law rule, it must be incorporated into the contract by signature, by notice, or by previous dealing. While according to statutory rule, it will be dealt according to Unfair Contract Term Act 1977 between business to business transactions and Consumer Right Act between business to consumer transactions. It is a summary of exclusion clause. Does the clause pass the common law rule, i.e., mean two conditions must be fulfilled, it must be incorporated into the contract, and does the wording cover the loss? If no, the clause will be considered invalid, mean void. If yes, then you should move towards the statutory rules. What is statutory rules? For business to business, if the contract is made in course of business, the exclusion clause relating to death or personal injury due to negligence will be considered void. And if there is a transaction between business to consumer, if one party is a consumer and the other party is a business, so unfair and not binding if not expressed in plain and simple language, cause an imbalance in parties. Mean will be considered valid if it is included by using plain simple language and both parties are in balance. So let's move forward towards another topic, discharge of contract. Mean when a contract will be finished. A contract will be finished if both parties have performed the contract, mean what the parties were agreed between each other, they have performed the contract will be finished. By frustration, where after contract is made, it is impossible to perform, like one party become dead, insolvent, or out of mind, unsound mind. So both parties have performed their promise, they have completed their promise, contract will be discharged. Or if parties are not able to perform the contract, mean it is impossible to perform the contract. Like the parties to the contract, one of the party is dead, is become unsound mind or insolvent. Or through mutual understanding, mean both parties agree with each other, okay, we will not able to complete this contract, then contract will be discharged. Our contract will be discharged if one of the party have breached the contract, either complete or partial. So in four situation, contract will become end if both parties have performed the contract, if it is impossible to perform, if both parties with mutual understanding decided, okay, let's finish this, and if one party have breached the contract. Let's discuss breach of contract. Breach occurs where one party to the agreement fails to complete contract either wholly or partially. Either wholly or partially. Following a type of breach, actual breach and anticipatory breach. What is actual breach? When breach occurs on due date of performance. Mean there was a contract on that date, I will perform this, and the other party, one of the party haven't performed on the due date. So that is actual breach. While anticipatory breach, where only parties shows intentions of not performing obligations. It is also known as renunciation. It is of two types. I mean, if suppose there was a contract between A and B, like B have to build a building for A on certain date. And 1 week before the date, only the 20% building was completed, and it is not possible to complete the 80% part of the building in 1 week. That is before due date. But one party has shown intention, mean other party knew about it, he is not going to meet the performance. So that is anticipatory breach. So breach can be of two types. Actual breach, mean on due date, one of the party of the contract haven't performed the contract, or anticipatory, where one party have shown intention of not performing. Mean renunciation, 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 renunciation. It is of two types, mean anticipatory breach is of two types, expressed anticipatory or implied anticipatory. What is expressed when one party declares before due date of the performance that they have no intention of carrying out contractual obligation. Mean they have stated we will not be able to complete the building on. Or implied anticipatory breach mean the other party have seen only 20% work is done and in 1 week 80% work cannot be done. Where one party does not does something which makes a subsequent performance of contractual obligation impossible. So what are the effects of anticipatory breach? Anticipatory breach does not automatically bring the contract to an end. The innocent party has two options. Either treat the contract as discharge and bring an action for the damages immediately without waiting for the contractual date of performance, as in H versus D law tour. What is H versus D law tour case? Let's discuss. In April, H is the claimant, D law is the defendant. In April, defendant D law tours employed H to act as a travel courier on his European tour, stating starting on 1st June. Mean they appointed H as their traveler courier for their business of touring, and his employment will start from 1st June. On 11th May, De La Tour wrote to H stating he would no longer be needing his services. Meaning they cancelled, they breached the contract before the 1st June. This means H knew about breach of contract by the D law. So H started proceeding on 22nd May. He sued the court for breach of contract for damages. And the defendant, mean De La Tours, claimed there would be no cause on action until 1st June because his contract will start from 1st June. But you have breached the contract before starting his employment. This means there is a breach of contract, and if he is new about it, he can sue you for damages. This is expressed breach or anticipatory breach. Anticipatory breach means your action have shown. So the claimant was entitled to start the action as soon as the anticipatory breach occurred. Implied anticipatory breach occurs where one of the parties does something which makes subsequent performance of their contractual undertaking impossible. And this is in case of Omnium D Enterprises versus Sutherland. Defendant Sutherland had agreed to hire a ship to the claimant, but before the hired period was commenced, he actually sold the ship to someone else. So the defendant had agreed to hire a ship to the claimant, means Sutherland agreed with Omnium. I will provide you my ship on rental basis on certain date, but before that date, he sold the ship. This means if he sold the ship, there is a breach of contract, and that is implied anticipatory. So they can sue them for damages. The sale of the ship amounted to a clear repudiation, mean rejection of the contract. So the claimant could sue for breach of the contract, though it is anticipatory but not expressed, it is implied. In anticipatory could be expressed, like in previous case, they have given notice, we gonna dismiss you, we're gonna not appoint you for the services. But in this case, this is implied. If he has sold the ship that is going to be higher on certain date in future, this means he will not be able to give a ship to him. So in case of anticipatory breach, the innocent party have two options. If A and B are the party of the contract and A breach the contract, so B is innocent party. So this innocent party have two options. Either they can sue for damages, or they can perform their part of promise and then sue for damages. So anticipatory breach does not automatically bring the contract to an end. The innocent party has two options. Number one, treat the contract as discharged and bring an action for damages. Like in the first case where they give notice to H, we no longer willing to use your services. So he has the option to sue, mean considering it is a breach. And if he has made a suit to the court for damages, this means he has considered the breach of the contract. So treat the contract as discharged and bring an action for damages immediately without waiting for the contractual date of performance, as in H versus De La Rua. And the second, elect to treat the contract as still valid, complete his side of bargain, mean he complete his promise, and then sue for payment by the other side. And he should start providing the services of a tour guide. I mean, he has meet his promise, but the other party is not meeting the promise, then he can sue for damages. So let's discuss another case between White and Carter and McGregor. They are claimant and they are defendant. So McGregor contracted with the claimant to have advertisement placed on litter bins which were supplied to local authorities. In McGregor asked W&C to advertise on the bins. Bins was placed in different public locations and those bins were maintained by W&C, and McGregor asked them, you need to advertise my business on the bins. There was a contract. The defendant wrote to the claimant asking them to cancel the contract. And then before the advertisement started, he canceled the contract to McGregor. This means W&C are having two options. Either they can sue for damages or they can perform their part of promise, mean they started advertising, they placed the advertising on the bins, and then they claim for the damages. So the claimant refused to cancel and produced and display the advertisement as required under the contract, and then they claimed payment. And McGregor said, no, as I have breached the contract with them with before starting the work, so I'm not liable for any payment of advertisement. But the court decided the claimant were not obliged to accept the defendant's repudiation, mean cancellation. Repudiation mean cancellation of the contract, but could perform the contract and claim the agreed price, mean they can receive the amount of advertisement. So in case of anticipatory breach, the innocent party is having two options. Either they can treat the contract as discharged and sue for damages. Either they can perform their part of promise and then sue for damages. Damages are a common law remedy. What is damages? Damages are a common law remedy. They are available as of right for breach of contract. Damages are intended to be compensatory, not punitive. I mean, these are the compensation for the breach of the contract. It's not a punishment. I mean, you need to pay amount, you need to bear the loss of the innocent party. Liquidated damages and penalty clause. Where a contract provides for payment of a fixed sum on breach, it may either be liquidated damages clause or penalty clause. Liquidated damages are a genuine pre-estimates of the expected loss. Mean what could be the loss? What could be the penalty? What could be the amount that need to be paid to the innocent party? That can be pre-estimates, mean can be calculated according to the loss. The amount stated in the amount of damages claimable, the clause is enforceable by the court or sometime it is decided by the court themselves. mean it could be pre-estimates or it could be decided by the court. Damages are a common law remedy. They are available as a right of breach of contract, and damages are intended to be compensatory, not punitive. And there is a court case, Dunlop Tires versus New Garage and Motor Company. Dunlop Tires, they are the manufacturer of tires, and New Garage, they are selling Dunlop tires. Dunlop have a contract with the New Garage, like you should sell the tire at say $40, 40 pound, not less than this. If you will sell less than $40, we will charge you £5 per tire. The New Garage was selling Dunlop tires. Dunlop are the manufacturer of tires. And to protect their market, they have an agreement with the New Garage. You should sell our tires either 40 or above, not less than 40. If you will sell below 40, we will charge you pound 5 per tire. And what happened? They sold the tires below 40 and Dunlop sue for damages of 5 per tire. But they refused. So the claimant, mean Dunlop, supplied the defendant with the tires under a contract which imposed a minimum retail price, say 40. The contract provided that the defendant, mean New Garage, had to pay the claimant pound 5 for every tire they sold in breach of the price agreed. Mean if they will sell below 40, they will pay damages of pound 5 penalty. When the defendant sold tires at less than the agreed minimum price, say 40, they resisted the claim of a 5 per tire on the agreed on the ground that it represented a penalty clause. But the court decided no, this was a pre-estimate, not a penalty clause. The provision was a genuine attempt to fix damage and was not a penalty. It was therefore enforceable because this was pre-estimate, mean these were pre-decided. Like this could be the loss in case of breach of the contract. Old penalty clause test. If a clause was not considered to be a genuine pre-estimate of the expected loss, then it was deemed a penalty clause and therefore not enforceable. It was not decided before. Then this will be considered as a penalty. A new penalty clause test in 2015, the Supreme Court provided a new test on penalties which replaced the old test. Like in case of C versus M, Parking I Limited versus Beve, the court ruled that the new test is whether the clause is a secondary obligation, which impose a detriment, mean loss, which all of the portion of the legitimate interest of the innocent party. If so, it will be penal and therefore unenforceable. Mean if it was decided before while making the contract, then that pre-estimate will be penalty. If it is not decided, then court will decide. Assessment of unliquidated damages. Unliquidated mean not decided while making the contract. Where the contract does not make any provision for damages, like that £5 was not decided, the court will determine the damages payable. And these are known as unliquidated damages. And there are two factors to consider in determining the amount of unliquidated damages. Remoteness of loss, mean what loss can be claimed for, and measures of damages, how much are those losses worth. Mean court will decide according to remoteness of loss and measures of damages. What does it mean by remoteness of loss? Damages cannot be recovered for all losses suffered because some losses are too remote. Too remote means too far. A loss is not too remote. A loss is not too remote. If it arises naturally from the breach, general damage or normal loss, it may be reasonably by supposed to be within the contemplation of the parties at the time they made the contract as a probable result of the breach, special damages or abnormal losses. So remote loss cannot be covered, but a loss will not be considered too remote if it arises naturally from the breach, mean arises due to the breach. Let's discuss a court case. Yes, H versus B. So H is a claimant and B is a defendant. So H owned a mill. One of the mill part had broken and C made a contract with D for the transport of the old part to the London as a pattern for making a replacement. So B was running a mill, and in his mill, one part of the machinery was broken, and they contacted H to deliver the part to the London. And H delivered the part too late. And due to late delivery, B suffered some business loss. And B asked the H to pay damages. So C owned a mill. Sorry, C, who is C? H. So H was a mill owner and B was a part provider, mean machinery parts provider. He's a spare parts owner. So H ordered B to deliver a part of machinery in London and B delivered the parts late. Might be the part was not available, might be it was not manufactured. And H suffered some loss of business due to late delivery because there was no production. So H sued the B for damages of business loss due to late delivery. As the contract to deliver a part and B was not aware that his production is halted due to that part. B was not aware that he will lose his business due to late delivery. So B was not liable to pay damages of loss of business for the H because the loss was too remote. It was not directly linked to the late delivery of the parts to the London. Obviously, if from one country to other country, the parts is going to be delivered, it will take time. There will be delays. So C on the mill, who is a CH, one of the mill part had broken and C made a contract with D mean B for the transport of the old part to London as a pattern for making a replacement. D was responsible for a delay in delivering the parts, and as a result, the mill was closed for a longer duration than would have been necessary if there had been no delay. C claimed for loss of profit during the period of delay. So D, mean the part provider, did not know that the mill was inoperable without the parts, and while he was directly responsible for the delay itself, so that stoppage was not a natural consequence of the delay in transportation. So C could have had a spare parts and did not alert D to the fact that a mill would be inoperable, mean he didn't inform the defendant, like my mill is not operating due to that part. So that why the defendant is not liable for the loss of business of C mean it. So until the new part was made, accordingly, D mean defendant was not liable for the loss of the business profit because that loss is too remote. It has no link with this main contract of delivery of. Can you understand this? Mean loss will be recovered if it is not too remote. If it is remote, this will not be covered. And then there is another case between Victoria Laundry and Newman Industries. So Newman have to provide a important component of laundry business that is called boiler. And without boiler, ultimately laundry business cannot be run. And if Victoria Laundry have ordered a boiler from Newman Industry, this means Newman Industry know about it. Like without boiler, they cannot run their laundry business and they will suffer business loss. And in this case, they delivered the boiler too late. And due to this late delivery, Victoria Laundry suffered business loss and they sued Newman Industry for the loss of business as well. So the court case decided this loss is not too remote. This is due to their late delivery, so they are liable to pay damages of Victoria Laundry. So Laundry required a new boiler to enlarge its plant, and there was delay in the delivery of the boiler, and as a result, the laundry lost its business. A normal trading profit from the delay in bringing the new plant into the use, and an extra large profit on certain government contract, meaning they want boiler to extend the plant because they received a contract with government party for laundry business. And due to that delay, obviously they lost profit on the government contract as well as their normal business. And they sue for both the damages. So the boiler manufacturer, mean Newman Industry, was liable for the loss of normal profit under the first branch of the rule, or anyone else would know that an industrial boiler was essential to the operation of the plant. And therefore, to earning normal profit from it, he was not liable for the loss of profit on government contract, but for the normal business loss, he is aware. So he will bear the loss. He need to pay damages for the normal business loss, but not for the government contract because they are not aware about the government contract, of which he had no information because this is too remote, but this was not too remote. He had known of them, he would have been liable under the second branch of the rule. If they are aware about this as well, then they will be liable. If they are not aware about this, but they are aware about the normal business, so they are liable for this, not for the government, because this is too remote. But this loss is not too remote. So in case of breach of contract, the innocent party can claim for damages of the loss. And if the loss is a too remote, they cannot claim damages. If the loss is not too remote, then they can claim damages. So that's it for today. There are some things more in chapter 2 that we will cover in next class. So the language of law is a bit complicated. That's why I have summarized the language. I have written down the language into easy lines, easy words. So try to cover not only these slides we are covering in the class, you have to read the book by yourself. Though I have extracted the main theme of the main content of the concept, and we are covering through book examples. So please try to read the book by yourself along with covering of these lectures. So see you in
Okay,
next
sir.
class with
Sir,
something new. Yeah,
can I ask you a question?
sure, sure, sure.
Do we have to practice the questions too, which they give, like
Uh,
the
in,
extra
uh,
questions in the
ex-
book?
uh, in book question you can cover, but for kit we will cover together.
Oh, okay, 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 okay. So,
The book
we
you
have
need to
to,
cover by yourself
okay, okay, okay. And
because I am covering
we,
the concept along with the cases, but the question of the book you need to cover by yourself.
okay, okay. And we have completed up to chapter 3, right?
No, no, we are just covering chapter one. We have covered, and chapter two we are still covering.
Oh, wait.
It's not
Okay,
ended
okay,
yet. There is
okay, okay,
something
okay,
more in chapter two that we will cover in next class.
okay, 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 okay. Thank you,
Okay,
sir.
see you then.